Hello, welcome to the weekly review program of Sawa Sawa Network. My name is Roger Alfred Yoron Modi. I'm the producer and the host. On January 30th, that's about 2 weeks ago, South Sudan's Minister of Information and spokesperson of the government, Michael McCoy announced that the Council of Ministers has approved the establishment of the hybrid court provided for in the Revitalised Agreement on the resolution of the conflict in South Sudan, together with related institutions. Chapter 5 of the agreement talks about transitional justice, accountability, reconciliation, and healing. Those are the institutions that are to be established, including the Commission for Truth, Reconciliation, and Healing, an independent hybrid judicial body to be known as the Hybrid Court for South Sudan, and Compensation and Reparation Authority. The agreement says the hybrid court shall be established by the African Union Commission to investigate and, where necessary, prosecute individuals bearing responsibility for violations of international law and or applicable South Sudan law, committed from December 15th, 2013 through the end of the transitional period. So joining me today for the program, I have Nyagoah Tutpur, a researcher, Africa Division, Human Rights Watch, and Jame David Kolok, Executive Director, Foundation for Democracy and Accountable Governance, and also is an activist and a researcher on transitional justice in South Sudan. Welcome to the weekly review.
Thank you very much.
Let me start with Nyagoah. You issued a statement welcoming the decision by the government to establish the hybrid court. You refer to it as a gleam of hope for South Sudan's victims. To our audience, just elaborate a little bit more on what this decision means.
Right. Thanks very much, Roger, for the opportunity to sit here and talk about this transitional justice program in South Sudan. Now, as you rightly put it, the government, after what felt like so many years, finally issued a decision approving the establishment of the hybrid court, as well as the Commission Truth, Reconciliation and Healing, the Compensation and Reparations Authority. Now, this step is quite significant in that these three mechanisms are supposed to address the legacy of conflicts in South Sudan, which means to arrive at the truth around what happened in the country, as well as to provide justice, healing, and compensation for victims. So this is a great step in that. The first time these three mechanisms were agreed to was in the 2015 peace deal. So if you look at all that time period between 2015 and this January when they finally approved it, it's been a number of years. So this is quite a significant step. We're obviously cautiously optimistic because there's a lot more that needs to be done in order to make this a reality.
Cautiously optimistic. What steps do you think should be done to get this moving forward in the right direction per the agreement?
Right. So, for instance, now the hybrid court for South Sudan is supposed to be established together with the African Union through the signing of a memorandum of understanding. Now, this memorandum of understanding has been pending since December 2017. So as a first step, the memorandum of understanding between the government and the African Union needs to be signed. And then from there, the African Union then needs to take immediate steps to around the staffing of the courts, around the location of the courts, and other technical details around the establishment of these courts.
Well, Jame David Kolok, this is also an area you do research also on transitional justice a lot. What does having the hybrid court mean to the people of South Sudan, given their history in the country?
Yeah, well, thank you very much for having me, Roger, in this very important discussion. But maybe before I respond to that particular question, I would like to also underscore the fact that when the approval was done by the cabinet, I think the civil society and the activists who are closely working on issues of transitional justice actually welcomed that approval. We welcome it because like what Nyagoah said, this is a process that would have happened considerably, maybe within the context of the 2015 peace agreement. But when you look at the period of the signing of the 2015 peace agreement until it was revitalized, you would notice that the approval of especially the aspect of the hybrid court came in literally as a surprise to many people. In terms of what it means to the people of South Sudan, I know that the chapter, which is chapter 5, provides for 3 various mechanisms through which transitional justice can be enhanced. However, through the period, there has been a number of narratives, especially of those who seems to believe that South Sudanese only, for example, need to reconcile, or South Sudanese only need to be compensated for the crimes and whatever they have lost during the conflict. The narrative of the issue of accountability, which is the hybrid court, has always been put aside, especially by certain individuals who would not want to see that go through. That not to say that South Sudanese do not want to seek for justice. In fact, it's to the contrary, that when you move around, you would clearly notice that the voices, especially of the survivors, are coming in to say, I think it is important that if we want to end impunity, and if we want to set a ground for addressing similar occurrences in the future, the question of accountability, and especially those who have perpetrated human rights, must be taken into an account. So we hope that by this process moving forward, the wishes of those who have suffered the consequences of this conflict would actually be addressed. And I hope that this time the narrative will shift towards defining justice from the context of the victims, other than defining justice from the context of those who would be actually perpetrators.
Nyagoah, Human Rights Watch, is a big organization, and the people of South Sudan suffered for several years, and maybe you tell us your approach on the crisis in the country in terms of the search for justice. Do you also consider the importance of compensation and reparation and reconciliation, given that actually this country has been in years, the people have been suffering for years in conflict and all those human rights violations? That's even over time, sometimes some even just got forgotten or disappeared in between.
Absolutely. I mean, I should have introduced. Well, as you've rightly put it, Human Rights Watch is an international organization that works on over 90 countries. In all these countries, we document human rights abuses and we advocate for justice. And we also advocate for an improvement or a change in people's lives. So, I mean, our work on South Sudan centers not only around conflict-related abuses, but also on other human rights issues. That are taking place in the country, working from home. Right, and so I have to underscore that the hybrid court, the Truth Commission, and the Reparations Authority, these are mechanisms that were arrived at by South Sudan's peace partners, the mediators, the African Union, and civil society. So in as much as we as an organization support these are mechanisms that South Sudanese themselves arrived at and decided that these are the 3 mechanisms that would contribute to truth-seeking, to justice, and to healing. And to not only, and all these mechanisms are supposed to have a bearing not only on South Sudan's present crisis, but it is also supposed to be a reflection on past atrocities and past violence that we have experienced as a country. In as much as I work for an organization, I'm also a South Sudanese, and I do understand the value and the importance of these mechanisms. It was just last week that, I have to underscore that it was just last week that a senior commander from the Lord's Resistance Army that had terrorized northern Uganda, parts of South Sudan, and the DRC was brought to justice after years of abuses and after years of also evading justice. And so that trial that is just so close to South Sudan, or that issue that is just close to South Sudan and across the border, is a perfect example to show that no matter how long it takes, justice will be served eventually, and that these processes have a bearing on victims and their healing and their ability to rebuild and to rebuild their future with hope. So these processes are just not processes on paper. They are processes that have such great significance for individuals in South Sudan.
Jame, let's talk about the Commission for Truth, Reconciliation and Healing. And one of the mandates and functions provided for in the agreement is that the Commission for Truth, Reconciliation and Healing shall establish an accurate and impartial historical record of human rights violations, breaches of the rule of law, and excessive abuses of power committed by state and non-state actors from the date of the signing of the agreement to July 2005. What do you say, especially given the fact that many things happened even before 2005, and to have truth and reconciliation and healing, also given that there was a commission established actually before the war to look into that, and that commission did not finish its work. Now things become complex, and this is the situation. In terms of the importance of truth, reconciliation, and healing, what do you say about that provision and the need to have truth, reconciliation, and healing?
Well, the peace agreement, and especially Chapter 5, provides for very clear processes through which these mechanisms should be established. And one of the processes that there should be actually legislations to start the process of establishing this mechanism, including the Commission for Truth, Reconciliation and Healing. Now, again, before even the process of drafting these legislations, the Ministry of Justice, in collaboration with the civil society, are supposed to do public consultations. And a public consultation in order to draw the attention of the citizens and also to seek their views in terms of what nature of legislation they want to see as far as the process of establishing the CTRH is concerned. Now, our first step and request would be that we need to expedite this process, which unfortunately or fortunately requires that the parliament should be reconstituted, because at the end of the day, it is actually the parliament that will have to pass these legislations. So the more we delay, the more problematic we'll have in terms of the timely implementation of these processes. Now, in terms of the duration, I think this debate has been made. Obviously, the architectures of the peace agreement decided that the CTRH period should be July 2005 to the signing of the peace agreement. But on the other hand, as civil society, we say that some of these concerns, especially that you have raised in regards to some atrocities that may have happened, are exactly cited in even the African Union Commission of Inquiry that has gone to cite some atrocities that have happened way before 2005. Now, it is up to the South Sudanese people, and especially the fact that the legislative process would be conducted. It is up to them to try to engage in that debate. And if they conclusively decide that obviously certain atrocities need to be seen before this period, definitely that would have to be considered by the commission. But one thing which is reality is that there is no way, for example, you can say you want to take an account of what exactly happened in July 2005 and beyond. In most cases, whatever you would be investigating within that period will in one way or the other have connections for something that would have happened way before 2005, or for something that would have happened way above the signing of the peace agreement. So I think as civil society would request for level of flexibility that must also be embedded in our debate on the issue of drafting this legislation to take into consideration people that still feel aggrieved because of atrocities that may have happened to them outside the period mandated by the peace agreement. In terms of the impact of the CTRH, of course, that is the basis through which reconciliation can be enhanced. So the manner in which we establish that commission would actually determine the trust and effectiveness of participation of either victims or South Sudanese in general. Like in your introduction, I've done two research that tried to ask some of these similar questions in terms of what citizens feel the commission should actually look like. Apart from the fact that the agreement, of course, clarifies that there will be 7 commissioners, in which 4 will be South Sudanese. The South Sudanese themselves are particularly concerned of who is going to be in this commission. Because the argument in that in South Sudan, it is quite easy to bring people into some kind of either committee or commission, and yet the same people could have been the same that are seen as actual perpetrators. So South Sudanese are saying that establish a commission made out of people of high moral integrity, and that the provision of the agreement that, for example, the commissioners will be determined by the presidency and submitted to the parliament need to be reversed. Citizens are actually urging that they need to be given a responsibility in suggesting who should actually be in this commission. So the idea of public vetting remains very, very important in ensuring that whoever finds its way to the presidency and to the parliament for appointment should have been somebody that has been sanctioned by the citizens as someone of moral integrity, of high moral integrity. This should be able to build confidence so that citizens can be able to participate in this process. Otherwise, if they do see that the individuals that will be occupying those spaces are actually people that are not trusted, or people that in one way or the other may have been complicit in some of these atrocities, then possibly the commission will be dead on arrival. So these are things that need to be addressed so that we can be able to have very reputable entities that can be able to engage in the process of transitional justice.
Nyagoah, would you like to add something on compensation and reparation, given that also is part of a very important part of transitional justice, and the situation in the country right now is complex. We have refugees, many of them have not been repatriated. You have people still suffering in some of the camps, and the implementation of the agreement also has been going slow, especially relevant provisions that have to do with the preparations for the establishment of the Compensation and Reparation Authority.
Right. I mean, like you say, the implementation of the peace deal is way behind schedule. Now, these mechanisms that we're talking about, the hybrid court, the Compensation and Reparations Authority, the CTRH, that is the Commission for Truth, Reconciliation and Healing, all these mechanisms were supposed to be established at least within 6 months of the commencement of the transitional period. Now, if the transitional period started in February 2020, it's been over a year. So these processes are overdue, as well as other processes, like as Jame pointed out, the reconstitution of the Transitional National Legislative Assembly. Now, with regard to the Compensation Authority, it is unfortunate that the peace deal has a very narrow understanding of what compensation and reparations is, because the authority that is in the peace deal is supposed to administer, there's supposed to be a fund that is created, a compensation and reparations fund, which would be managed by the authority or administered by the authority. And so this reparations authority is to provide material and financial support to citizens whose property was destroyed by the conflict and help them to rebuild their livelihoods. So when it says citizens, it's both natural and citizens in the basic understanding of law, including companies, for instance. Corporations and companies that are instituted in South Sudan can also claim citizenship as well. So the compensation that is thought about in this instance is that it would be financial compensation, and it is only for individuals that have their property damaged. But there have been a myriad of abuses that have citizens have suffered in South Sudan. And these abuses, there needs to be compensation and reparations for this. Now, reparations include, compensation is a form of reparations. Reparations also include a guarantee of non-repetition, which could include certain reforms in various institutions to ensure that the kind of abuses that took place do not happen again. They also include restitution, in that the victim or the individual is returned to the place that their life was before the incident occurred. And I would remember that in 2015 there was resistance to the Reparations Authority, in that it would be susceptible to abuse because the entire country would qualify, because in fact there are there's a multiverse of victims in South Sudan. So it would be important also, in as much as this Reparations Authority will be established, it will be important for this government to think through the broader concept of reparations, whether it is reparations that can be provided through trials, or reparations that can be administered through government programs or government services.
And with regards to the delays in the implementation, especially of related provisions, there have been suggestions about amending the agreement or changing the timelines. What would you say about that? Is that something, because with amending the agreement comes also extension of the period of the transition and those in power. So now with these two, you find for the greater good, where do you lie in terms of those suggestions and talks?
Yeah, well, I'm going to let Jame have that one, but my initial thoughts is, if there's been zero progress this time, what will an extension do? And what does this mean for the lives of South Sudanese? I think the important thing is, what value does it add to the greater public good by ending the transitional period? And how does this impact South Sudanese ability to also decide who's going to lead them as a country and how the affairs of their country will be run? So I'm going to let Jame run that, but it's a tricky one, I would say.
Jame, you can say something briefly about that.
Yeah, I think this is a very interesting debate. The same question was asked sometime. For example, when we had almost indefinite extension during the pre-transitional period, and somebody asked, they still want about 100 days. What are they going to do in actually these 100 days of the last extension? Now, my argument is that if you cannot do anything in 8 months and 6 months more extension, you probably cannot do anything in 3 months of the extension. So it is just the same thing that I think the question of extending the transitional period need to be embedded in a reason that can be convincing to the South Sudanese people. We believe that this is going to be a total of more than 36 months. So if truly these parties are not able to establish anything within this period, then I'm not sure South Sudanese are just going to accept it, that they will just be doing extension for purposes of maintaining the status quo. I think there must be evidence to suggest that if there is really any extension, which I feel is not going to be likely, then South Sudanese need to get convinced that it is something beyond the capacity of the parties, and therefore it will require that extension. But the way things are moving, I think it is very clear that I think certain things are just deliberately delayed, and therefore would have loved that the parties actually work hard to make sure that they put their effort to implement the peace agreement. I think it is too early to talk about anything regarding extension, which we hope it will not happen. We believe that within this remaining period, there should be some major steps taken, obviously because of the fact that some of these provisions within the peace agreement do not actually require even 36 months. These are things that can be decided even in a day or in a week, and the implementation would be seen to happen. So I think that is our position, and we don't encourage any extension at all.
Well, as we head towards the end, you give us an overview about the hybrid court, the intention, how it is intended to operate, and including the rights also the accused and also the victims. You know, just for the understanding, for the benefit of our audience.
Right. Well, the hybrid court is supposed to be an independent judicial mechanism that is, like I said, to be established together with the African Union Commission. And its mandate is to investigate and, where necessary, prosecute individuals who bear the highest responsibility or who bear responsibility for violations of international law and or South Sudanese law. So these are war crimes, crimes against humanity, and it also has primacy for genocide. Now, it's supposed to be dealing with crimes from 15th December 2013, which is when the conflict broke out, and the end of the transitional period, whenever that may be. So the AU Commission is in charge of the creation of the court, in that it's supposed to be providing guidelines regarding the location of the courts, its infrastructure, the funding mechanism of the courts, the enforcement mechanisms, and even the applicable jurisdiction. It will also decide on the number and composition of judges, issues around privileges and immunities of court personnel, and other issues. Now, South Sudan, well, the peace deal provides that South Sudan should pass legislation for the court's establishment. And as Jame said, it is important that the parliament is established as soon as possible in order for this recent decision to actually be operationalized. But also the African Union has the power to unilaterally establish the courts. And so for the last 1 year, we as an organization have been calling for the unilateral establishment of the courts, because South Sudan was taking steps to delay the signing of a memorandum of understanding with the African Union. So back to it as well is that, so the court is supposed to comprise South Sudanese and other African judges. And the majority of judges on the panel are supposed to be citizens of other African countries. So the court's judicial selection procedure is exclusive authority of the African Union Commission. And so the commission is going to appoint judges, whether these are South Sudanese or international judges. And the chairperson will also appoint the prosecutors and the defense counsels. Unfortunately, South Sudanese cannot serve as prosecutors or defense counsels in this court. That is according to the provisions of the peace deal. And also South Sudanese cannot serve as the chief administrators or the registrar of this court. They can serve in other capacities as well.
On the issue of the defense counsel, don't you think that there is something to do with infringement on the rights of the accused? You know, you're supposed to bring your own defense counsel.
Absolutely. And I think this is something that the AU Commission has to consider, because every accused person has a right, both by South Sudanese law and international law, to choose a counsel of their own, to choose their own defense counsel. So I found it really interesting. It was very unfortunate that this provision made it into the peace deal. And I'm hoping there would be further considerations made that would allow accused persons as well as witnesses and victims to choose their own lawyers of their own choosing.
Well, in a maximum of 2 minutes each for you all, give us your final thoughts, your views regarding the hybrid court and transitional justice as a whole. What should be done moving forward? What are the important things? What should be the hopes of the people of South Sudan?
Yes, I think we believe that by the parties signing the agreement, they commit to implementing it in totality. And that applies to Chapter 5 as well. We believe that the various mechanisms provided in that particular chapter should be holistically implemented without segregating any of them. Now that this process seems to start by the meeting that has approved the hybrid court, and that South Sudanese will have confidence that they would be having the opportunity to benefit from all those other processes. The other one is that time is actually running, and we hope that this process is not going to delay to an extent that South Sudanese will continue lamenting and wondering whether the commitment is there to implementing this process. So this is our call, that we want to see this process expedited. We want to see the African Union come in quickly, and we want to see the MOU, for example, and the statute pass to be able to assure us that there is commitment in the process.
Nyagoah?
Yeah, I mean, I greatly concur with Jame. You know, Chapter 5, we have to look at the peace deal as a whole package. And it is unfortunate that we're still stuck, 1 year later, we're still stuck in issues of governance and security. And we're yet to make it to actual issues that might translate into value for the South Sudanese people. Institution building and institution reformation that would have an impact on people's lives. You know, there are certain provisions in the peace deal, including reconstruction and how refugees and returnees and IDPs and other victims can be assisted by their own governments. So I think these issues are really important in that it is important. I think, you know, we're all very pleased that the Minister for Justice, as well as the entire cabinet, have approved these processes. And they should not lose momentum in getting these mechanisms up and running. They've taken a great step. Let them not wait for another 6 months, another year, another 3 years. The time to act is now.
Well, our dear listener, with that, we have come to the end of the program, the weekly review. We have been looking into the issue of the hybrid code approved by the Council of Ministers of South Sudan, and Chapter 5 in general, which talks about transitional justice, accountability, reconciliation, and healing. And with me in the studio, I had Nyagoah. She's a researcher with Human Rights Watch, and Jame David Kolok, an activist and also a researcher on transitional justice. Thank you very much for being on the program.